Hey friends, it's Latoya McBean Pompey, immigration lawyer here in Long Island, New York. I'm answering questions in this video about things that you asked me about after I posted my video on consular processing versus adjustment of status. I'm answering those questions in this video. If you're interested, stick around. Also, friends, is that I have a free download to that video, and there was a little error on the download, a little typo that someone pointed out to me. It's actually an important typo, and so I made the correction and I re-uploaded this document. So the correct version of this download can be found on McBean Immigration TV under the video called Consular Processing versus Adjustment of Status. I'm going to read the questions. Some of them are comments that I've received from you guys recently. I can't go through all of them. I will try my best to maybe answer about 7 or 8 of those. All right, so here goes. First one comes from a woman named Nikisha. She says, I love your videos. You're doing a good job on informing the public about what's going on. I have a question. I have a 17-year-old niece that is in the US on a visiting visa. I would like to file for her. What's the best way of doing that? So friends, what you should know is that firstly, Nikisha won't be able to petition for her niece, right? Because under our law, there really is no system set up or mechanism that is available for an aunt to petition for a niece. It doesn't exist. That's a category that does not exist under our system. So she cannot petition for her niece for a green card. It's not going to happen. I think that's all I want to say about that. There's nothing more to say about it. Can't be done. Let's scroll down. By the way, if you send me really long comments and questions, chances are I will not read them because I just don't have the time to read the very long ones. So I have actually just skipped over those because I don't have time for that. But here's a question, a short question that came in from Joshua. He says, my case was denied. I'm sorry to hear that, Joshua, but his case was denied because he moved to another address. What can I do? I don't know what kind of case this is, but let's just assume that it was a green card case or green card matter. If you got the denial because you moved to another address, I don't know whether you're within like a 30-day period to maybe even file a motion to reopen or reconsider. I think those motions are a waste of time because they typically take a pretty long time for you to get a decision on those motions. The motion to reconsider or reopen the case can take, from what I understand, up to 15 months. And meanwhile, you're sitting there doing what? Waiting. I don't know if this was for adjustment of status, if this was for a work permit or whatever. I don't know what you've applied for, but you may need to refile because you don't want to dwell on any one issue too long because that also increases the amount of time that you're waiting, and you don't want to wait too long for your benefit to come in. So I would just say that you may need to refile depending on what it is. Next question comes from Starboy. Starboy asks, how can I join your email list? Very easily by clicking the link below in this video. Basically, most of my videos I do and post, I do indicate how you can join. You should join because I do send out very good stuff each week. So click the link below and get on my email list if you have not yet joined. Now, Rocky says, thank you so much for your very informative videos. We're learning so much. Not sure if this question was asked before, but here goes. If my husband overstayed his time and I am a resident, can I petition for him? How long will it take? This is a longer question and I can't get into all the nuances. But in short, I will say this. If you're a resident and you're petitioning for a spouse who is here in the US who overstayed, what's going to happen is that spouse is going to hit a bump in the road. Bump in the road. What is that bump? Well, that bump is an issue of inadmissibility because he overstayed, and he will need a waiver of some sort to get over it. If the petitioner is only a green card holder, there's limitations on how far that spouse can go in the green card process here in America. So what happens often is that that spouse who is up against this bump in the road, or a wall really, will need to file a waiver of unlawful presence so that he may consular process in his country. He has to go back to his country and go through the U.S. Embassy process there if he is eligible for the waiver. Big if. Watch my old videos on the I-601A waiver and what it takes to be eligible for it. Not everyone is eligible for it, but if a person is eligible for it and he cannot adjust his status here because he overstayed and he's only married to a green card holder, he's gonna have to do that. Or, here's the better way. The better way is this. Rocky, become a U.S. citizen. Become a U.S. citizen so that your husband, right, he can get a green card here in the U.S. He could adjust his status. All things being considered, if he meets the eligibility requirements to adjust his status, the issue of him overstaying is an issue that the government will basically kind of look the other way and forgive him for without him needing to file a waiver for that. It's not an issue for those who came here lawfully using a visa at the border or the airport, and they came in and stayed over. But if they marry a U.S. citizen, they're married to a U.S. citizen, and they have no other issues of inadmissibility plaguing them, then yeah, they can adjust their status. And so I would say to you, Rocky, what is standing in your way of becoming a U.S. citizen? Is it time? Is it the fact that you need more time? You have to wait another year, 2 years, 3 years, however long. Is that the issue, or something else going on? If you're eligible for citizenship, you should get it. Who wants to think about Donald Trump coming into their life and invading their life? I mean, come on. You want to be free. So you can only be free if you become a U.S. citizen. And so at that point, you'll be able to petition for your husband, and he can file for adjustment of status here. Otherwise, he'll have to go around and around, go through this long-wieldy process to get the green card. And for some people, it's a major risk to think about consular processing. That risk is this. You get to your country overseas and you're being interviewed at the U.S. Embassy, and they bring up some old issue you forgot about, and that issue is a problem to that embassy official who is interviewing you, and they're like, we're going to deny this because we found this other issue of inadmissibility. You can't go back. Sorry. Doesn't matter that your wife is in the USA. Does not matter. You're risking it. It's a risk when you think about going back to your country to be interviewed. So you've got to make sure that before you go down that I-601A waiver process, that everything else about you is really in order, and you're being truthful to your lawyer and telling your lawyer every single thing about your past in that country, in other countries, here in the U.S., and run every kind of background report on yourself that you can, FBI background report, other reports from the country where you're from, background checks, police records from countries where you've stayed for more than a month or 2 or 3. You've got to make sure you're sparkly clean. Is that how they say it? Sparkly clean? Don't know. Anyway, you've got to make sure there's nothing else there. Because if that embassy official doing his or her database searches and all of that, they find something on you, they're not sending you back to the United States, even though you've gotten that I-601A approval. It's risky if you have something to worry about, and only you know that. This might be the only pathway for some people, and it works. It does work. It is a pathway to a green card. It does work for some people who have no other option. And if you're here and you have a clean record, the only issue for you is you just overstayed and you go back home to be interviewed, you should be fine. Now, this is the wrinkle in everything. And the wrinkle is public charge. I'm spending a lot of time on this question because it's a hefty topic. I may do a lengthy training on this. It's in my mind to do a lengthy training on this, but think about public charge right now. Public charge can impact Rocky's husband down the road if he has to go consular process, because the government, the Department of State, is still going through its process to finalize things before it fully implements public charge. We're thinking that maybe sometime in December, it's gonna be implemented by them, unless a court stops it temporarily or something else happens. But at this point, they're looking at from what I understand, a December date. They've already been tweaking some things. Even earlier this year, they did tweak some things with respect to their rules to look at age, health, income, education skills. So some of your relatives are going through consular processing right now, and they're being asked, and I've been hearing this in consultations, they're being asked questions like, what are you planning on doing what are you doing with your life these days? What are you working towards? Are you really looking to see what the person's ambitions are and skill levels are, and whether or not they're going to come here and ultimately go on public welfare one day. So we know that on the consular level, to some degree, those questions are being asked of some people, from what I've been hearing. That's what her husband will encounter as well. So if he goes to that embassy and he's not fully equipped and ready for that public charge fight, he can be denied and stay there instead of coming back to be with her until they overcome those issues at the consulate level. So it can be really messy, friends. But like I said, for some people it works, and it works only for people who have a really good, clean background. Now let's move on. Antoine has asked, could you please explain to me the K-1 visa? Friends, the K-1 visa is something I don't think you've heard me talk about before. I think I only have one video on it, one of my ancient videos, but good nonetheless. Short, ancient video I did on fiance visa. I don't really do much on that. If you want to learn more about that from me, can you guys hit me up in the comments below and tell me K1, K1, K1 with maybe 2 thumbs up? Just say K1, K1. 2 thumbs up. That way I will be able to, and my assistant and other people who help me with all of this, will be able to look at those comments and say, that's a good topic. Let's get some videos out on it. Otherwise, I'm not going to spend my time on that. So unless I see you guys asking me for that in a real strong way, I'm not going to really address it. But I'm happy to do so, but I need to know you want this. Karina says, can you do more videos about a green card holder parent filing for a child? I want you to tell me, Karina, what is it you want to learn? What about this process do you want to learn? Because in my view, it's pretty straightforward. It's a filing of the I-130 petition. You attach your birth certificates. There's really not much to it unless there's some nuances that you want me to address, or it's just, to me, it's a straightforward process. So I'm happy to maybe answer your question in a comment, like on YouTube or Instagram or Facebook, but for the most part, I don't really see myself spending a lot of time answering questions about that, or doing a video about it, unless you tell me, what is it you want to see? I have some old videos on like case processing times related to this topic, so go back and check out those old videos. And then my old Pathways to a Green Card series also touch on this topic. So I would say go back and look at those, and yeah, enjoy those old videos. All right, the last question that I'm gonna answer is from Taskian. Hi, if you have a child and stay out of the country more than 7 years, him or her will have a problem going back on a green card from Jamaica. So I think this is about abandonment of residency. If I'm wrong, ask your question in a different way. Reframe it, please, because I can't really get more than this out of it. So if the question is about whether if you stay out for 7 years, you'll have problems coming back to the US on a green card, the answer is definitely yes. Because if you even stay out for a year or longer than that, the government is going to accuse you of abandoning your residency. The issue with this is, let's dive a little deeper. Residency, to be stripped of your green card, friends, or to be stripped of lawful permanent residency, that action can only be done by a judge, an immigration judge, an immigration court, not USCIS, and put you straight away into removal, into immigration court, and you have to battle it out in court and prove to the judge that although you were gone for that length of time, that actually, you maintain your domicile, your residency here in the US and such. You'd have to battle it out in court, but that's a messy process in and of itself. I would think you have significant problems getting back in the US from the border. They may give you a hard time, but if you do get back in, if they do allow you to come back in, they will stamp your passport, you will be put in removal, and you have to argue why you think that you never abandoned your green card. That's the best answer I could give right now based on what I'm understanding from your question. All right, friends, I enjoyed this. It was wonderful. I'm sorry I'm not able to answer more questions than this, but in a nutshell, please keep your questions short. If you would like to get on my email list, do so by clicking the link below. Super wonderful email list. Get on it. And friends, I'll see you in the next one. Bye-bye.